My name is DJ Bettencourt, and I have the pleasure of serving as the Deputy Commissioner of the New Hampshire Insurance Department. I'm going to keep my introductory remarks brief this morning because we have a lot of material to cover. Without a doubt, the most frequent question our consumer division receives when it comes to auto inquiries or complaints is, what is the total loss value or actual cash value of my vehicle, and how does an insurance company reach that determination? We fully appreciate that this can be a confusing topic for consumers, so we are very excited to discuss this process with you to help demystify it for consumers, because the reality is, unfortunately, many of us have been involved in some way in a motor vehicle accident, and this is a topic that you're going to want to have somewhat of a firm understanding of. So to help us get to the bottom of it this morning is James Fox and Doug Rees, two top leaders in our property and casualty division. So I'll turn it over to them.
Thank you. Good morning, Mr. Bettencourt. Thank you for being with us this morning. As the Deputy Commissioner stated, one of the most common complaints we get in our Consumer Services Division is a disagreement between the value of my vehicle versus what the insurance company is offering. So we have put together a brief presentation today to try to address and demystify, as Commissioner Bettencourt said, the ways in which insurance companies determine the value. So we can start with Administrative Rule 1002.15, which is on our website, which provides general guidance to how insurance companies evaluate a vehicle. In summary, if you look at the definitions, we start with the term fair market value, which means the price at which an asset would change hands between a willing buyer and a willing seller when neither is under compulsion to act and both have knowledge of all the facts. That's a very common definition. Second, we look at the local market area, which means a distance of 75 miles surrounding the area where the motor vehicle is principally garaged. However, that does not necessarily mean it's limited to the state of New Hampshire. And lastly, we look at the definition of motor vehicle, which is not an insurance definition, but a Department of Safety definition in RSA 25960, which defines a motor vehicle as a self-propelled vehicle not operated exclusively on stationary tracks, except for tractors, crawler-type tractors, and electric bicycles and mopeds. So basically, your everyday commuter vehicle, car, pickup, motorcycle would be considered a motor vehicle. So in evaluating vehicles, INS 1002.15 gives insurance companies several options on how they want to use the evaluation. The first of which is a methodology that is submitted to the department for review. Currently, we have 6 methodologies available. These are done by independent vendors, and they submit the documentation to us for review. The second option, if they don't want to use a methodology, is the average sales price of at least 2 vehicles of like kind and quality that have been sold in the last 90 days. On our website, you will find a list of acceptable methodologies and their contact information. And some of them you may recognize and some of them you may not. One of the concerns that we have is that not all the methodologies have a consumer-facing website or presence in the market face. Some of them you may recognize, some of them you may not, but what frustrates consumers is they cannot go to these vendors and get an evaluation on their own. We understand that, and this is why we post this information on our website. I'm going to go back for just a second and talk about how these companies actually arrive at the valuations. Each of them uses proprietary data and algorithms. Essentially what they are doing is entering your information based on your VIN number and comparing it to other vehicles that are posted for sale locally. Those resources can be sites that you may be familiar with, like cars.com, cargurus.com, AutoTrader. or your local dealership. So the algorithms will go out, collect data for cars that are for sale locally, and then because the law allows them to manipulate, smooth, or adjust the data, their algorithms will then adjust for things like mileage or options, and then calculate the value based on that. It's really no different than if you went out and looked, if you were shopping for a vehicle, you could find the same vehicles, and then you would make adjustments for condition, mileage, or options as well. This is just an automated process. What happens when you don't like the number they offer you? Well, 1002.15c provides some relief. There is a dispute resolution process in that, and consumers can simply find their own comparable vehicles and submit those to their insurer. And by rule, the insurer is then obligated to recalculate the value based on your comparable vehicles. And the only exception to that is if a vehicle is in better shape and condition and can be purchased locally, then there is no reliable evidence protection, unfortunately. Under the rental, insureds have a right to rental coverage on their policy, and claimants as well. And they're entitled to rental for at least 5 business days after the insurer makes a fair and equitable offer consistent with the unfair claims practices. This is important because we want consumers to understand that they have 5 days, at least 5 days, but that needs to be with check in hand. So if your insurance company says, well, here's your offer, but we still need to get the payoff figure, we need to get a power of attorney, a bill of sale, that's not really protecting the consumer. So when the check is ready to be issued and you have use and constructive use of the funds, you should have 5 days beyond that. As far as the settlement, you'll be asked to move the vehicle. In most cases, the vehicle will be at a tow yard or a body shop. It'll be collecting storage. You have an obligation to cooperate under the policy. A lot of people don't want to move the vehicle because they feel it's their leverage to get a good settlement. But ultimately, the vehicle is licensed and titled in your name, so you are responsible for the storage. Move the vehicle. You still have the title, and that is your leverage to get the claim settled the way you want. You'll also be asked to sign a bill of sale or provide a title. Even in New Hampshire, if you don't need a title, you still may be asked to provide one. You'll also be asked for a limited power of attorney and a dominer statement. These are all required because you're essentially selling the vehicle to your insurance company. To make this process go a little smoother, if you have a loan on your vehicle, you should call your lien holder and get your account number, the payoff, the per diem, and find out where the insurance company can send a check to. That will speed that process up. They will not, your lien holder will not allow the insurance company to have that information. So we'll open it up to any questions.
Yeah, I would like to just say a couple of things to jump in for a second. So a lot of this goes back to, in the first instance, we're dealing with a lot of basically comparables. So if a consumer gets a number and they don't agree with it, look at the comparable that the company gave you, the report, and try to go get your own comparable, and then submit it to the company as soon as you can, and then say, I want you to look at this too, and I want you to reconsider. That's really important to do. The other thing that's super important is in the rental section, the key there, this also for companies, is that the department expects that the companies not give an offer and then have like 15 things that need to be completed before you get your check, and then have them be serial, like step 1, and then after you do step 1, we'll consider step 2, step 3, step 4, step 5. That we expect companies to move quickly to get the person who has the total loss a check, so that they can actually use that money to purchase a vehicle. That is super important. We do get some complaints there in terms of the speed of getting the money. And that's why we put in the section about consistent with the unfair insurance trade practice, that it has to be an offer that the person can execute on fairly quickly. So those are basically the 2 points I wanted to make before we went any further. And again, this is all under the claims, our claims rule. And I always say if anybody has anything they think that would make the rule work better, then they can contact either myself or Doug, and we'd totally consider making changes. But then with that, we'll throw out to any questions that people out there might have.
Could you explain like, kind, and quality LKQ for INS 1002? And then there's a second part to that. Is LKQ identical or non-identical as the NHID currently defines it?
I don't think it is.
It's not identical. It's like, kind, and quality. So the whole process is that the comparable should be of like, kind, and quality, and then you have to make adjustment because nothing in the world is ever going to be identical. So that would be an impossible standard for the insurance companies to meet. So we use, as with parts, that it's supposed to be of like, kind, and quality, and then we have to then make adjustments. So if you make the standard too stringent in terms of saying it has to be identical, then you would have a situation where the insurance company could never meet our standard, and then we'd never be able to arrive at a number that is appropriate to protect the consumer. So we need to have a little flexibility. So the whole design is the company, they get the comparables through a vendor, and then the adjustments are made. If someone doesn't like the comparable, they think it's way off, or they don't like the adjustments that need to be made to bring it into LKQ, then that is something that they should file a complaint with the department, and we absolutely will go through the report that the company obtained, and if we don't like the report, we will tell the company they need to get a new report from the vendor, and if we don't like how the vendor is operating, we will work with the vendor to bring them into alignment with the law, and we've done that on a few occasions that we've felt that the company could have done a better job.
Yeah, let me comment on that. It also, like, kind, and quality in that context means it gives companies and the insured, the claimant, flexibility to say, I cannot find a Toyota Camry DX within 75 miles. However, there is an LXI version, and again, it's comparable, like, kind, and quality, but we still need to adjust for maybe the features that are on the LX model versus a DX model.
Was not mentioned that the insured has the policy right to dispute the amount of loss with the right to appraisal? I'm not sure if that's a question or just a statement.
Yeah, the administrative rule, it has the appraisal process built into it. So my understanding is in submitting the comparables under the dispute process in C, that would supersede the policy appraisal clause.
The total loss rule is the total loss rule, and it does have basically the rule itself is designed to for both liability and first party. You wouldn't have a right to appraisal and liability. So in the way it works is the comparables are done, and if you don't like if the company identifies the car as available and you can go purchase it for the amount that they're saying, so they say your car is worth $10,000, and they say here is your car within the zone you can go buy right now, then you actually can't dispute that. You have to, though, because you have a right, you have the ability to go purchase the exact car. It's then if that isn't the case, then you have a right to dispute it by the comparable process under the rule.
Okay, thanks. We have another question from Michael. Does the insurer have to share all valuation reports with the insured? For example, if a condition adjustment has been made updating the value, does this valuation need to be shared as well?
Yes, it does. It's a very important part. James touched on it. The report has to be provided, or a report has to be provided to the insured to explain the methodology or the adjustments to the vehicle. And that's a common complaint we get, is the the report doesn't seem to get to the consumer, so they can't read how the adjustment was made, or they don't know what it's based on. But yes, they are required to provide it to the insured or the claimant.
And then one more question: are insurance appraisers that are setting these values of actual cash value and appraising the damaged property regulated by the New Hampshire Insurance Department?
Just to go back, the appraisers aren't regulated in the total loss. What's regulated in the total loss is that the methodology. So it's really it tends to all go back to comparables, but the methodology. If a company's just using a straight methodology, that's reviewed by the department to make sure it's analytically sound, so we're in essence up front, almost like in a form situation in insurance, reviewing what's been submitted to make sure that we're okay with it. And then the other options are to do the documented sales or the quotations. There are other ways to do it, but it tends to all come back to comparables. So we're up front. The process is a comparable process. It isn't like somebody goes out and starts writing an appraisal in a total loss situation, like you'd think of it as within a repair situation. The total loss is usually driven by, because you're not fixing the car, you're going to go purchase a used car perhaps. So it's like, how much value was that car worth based upon comparables out in the local market. That's the process.
Okay, seeing none, I appreciate everyone tuning in to this month's webinar. If you have additional questions that we didn't cover, by all means, I encourage you. Oh, there's one more that just came through. Can an insurance company deduct from a client's settlement value fees paid to a body shop to include storage fees not relating to after an offer has been made?
To take that on a case-by-case basis.
Yeah, that would be better. That question is if you send me an email, I'll be able to spend some time unpackaging and talking to you about exactly what you're talking about, but that doesn't jump out at me as a quick answer.
Yeah, that's fair enough. And I do encourage folks who may have additional questions or want to continue the dialogue with our regulators to email us, and you can contact us at communications@ins.nh.gov, and we will forward those questions to the appropriate subject matter experts here so that we can follow up on that. I appreciate everyone tuning in. Next month, we'll be discussing staged accidents, and it will be geared more towards members of the law enforcement community, but I think members of the public will be informed as well, and we hope that you will stay tuned for that. Now we'll turn it back over to Deputy Commissioner Bettencourt for some final thoughts.
Andrew, you've done a great job covering it. I again want to thank everybody for joining us this afternoon, and I would reiterate to Andrew that this will be available on our social media platforms for anybody who wasn't able to tune in live. And I want to really thank James and Doug. This webinar is going to be a phenomenal tool for the department and specifically your colleagues in the consumer division to share this with consumers so that they can have a better understanding of this process as they may encounter these unfortunate situations. So thank you all very much and have a great rest of your day.